The information provided in this podcast does not and is not intended to constitute legal advice. Instead, all information, content, and materials available in this podcast are for general information purposes only.
All right. So this is a guest that I've been very, very excited to have on, David Hathaway. David is an intellectual property and litigation attorney. We're going to be talking a lot about trademarks and for student athletes, how to really protect not only themselves, but their names and who they are. And I think this is a subject that is really important that not a lot of people are talking about. So Dave, thanks for joining.
Well, thanks for having me, Pete. I appreciate it.
Yeah, Dave, we talked a little bit before coming on here. Unfortunately, I'm a Yankee fan and you're a Red Sox fan. So I hope that we can keep this civil and I hope we can keep this fun. And I think we'll do just that.
What about Duke and UNC? Do you have a favorite there?
I'm a Florida State guy, actually.
Okay.
So are you a UNC or a Duke guy?
Yes, I'm UNC. So that's the other rivalry that I run into quite a bit down here.
All right. The 8 mile stretch, right? So
yes, it is.
Very nice. Well, it's a pleasure to have you on. Before we kind of get into the meat and potatoes of trademarks and, why it's important with name, image, and likeness and how athletes can protect themselves, can you kind of tell us a little bit about your background and how you got into IP law and also how you came to be doing what you're doing?
Sure, absolutely. As lawyers and many people realize there are a lot of things you can do with a JD degree. So I happened to go into private practice. I got out of law school in 99, and I have been at this law firm of Dean Mead since May 1st of 2002. So it's been almost 20 years. And my practices are business litigation, trust and estate litigation, and intellectual property.
Amazing. This is just for me. The listeners probably won't care. Did you go straight into private practice after law school?
I did. I did a clerkship first at the North Carolina Court of Appeals because I went to UNC Law School. So I did a clerkship with the judge. I then worked for a couple years at one of the 10 largest law firms in the world, and then moved to my current firm in 2002.
Awesome. I only ask because I never know if someone was a public defender or state attorney, and I started off as a public defender. So I always tend to ask those questions. All right. So we are really here to talk about intellectual property and trademarks. And I think that term is thrown out a lot. What is a trademark?
Yeah, and that's a good question. I just read an article where someone misused the term copyright for trademark. So a trademark, when you're talking about a trademark, it's going to be either a name, whether it's a person's name, a business name, or a logo, or a slogan that connects the source of a product and service to that product and service. So, for example, if you see, a FedEx truck, right away when you look at the logo on the side of the truck, that's a trademark, meaning that which most people recognize. And when you see the mark, you know the company. That's the idea about trademarks.
Why is it important then for someone to have a trademark if they own a business or if they're a student athlete trying to engage in name, image, and likeness?
Right. Well, trademarks are important, number one, because they're valuable. The more people hear a trademark, they will maybe be more apt to purchase the goods and services. And they're important. First of all, you want to make sure that when you're undertaking a new venture, you don't want to take a name that someone already has. So that's one important step. And then secondly, if you are pretty confident that you're going to be the owner of this name, you should protect that so nobody else can use it for a competitive advantage against you.
And I think you kind of just touched on this, but what are some of the benefits to having that trademark?
Yeah, some of the benefits, well, there are state and federal, first of all, and state trademarks are a little bit easier to get, but they are only good throughout the state. Federal are marks where you're going to be using your trademark across state lines, theoretically. Even the customers could be across state lines. But the benefits are to protect your mark from being copied by someone else who's trying to take advantage of your hard work and use it on maybe their competitive goods and services, even if it's not exact, if it's what they call confusingly similar, you want to protect against that.
Do you have any examples of a situation like that where someone had, didn't have a trademark and their name was used and they weren't able to actually bear the fruits of that labor?
Yeah, there's the Tom Brady example from a couple of years ago. I think Tom Brady wanted Tom Terrific and then realized that Tom Seaver had been known as that. But there are many examples where a business, they're set on a name, or an athlete has something in mind that they really like, and they find out that either they need to choose something else because that one's already taken, or they go ahead and resolve any potential dispute with a third party.
So Dave, you brought up something even as a lawyer for myself that I'm not really familiar with. And I kind of want to touch on that. I always thought that when you file for a trademark, you file for a trademark on the federal level. I didn't know that you can actually file for a state trademark. What is the real differences, and is it really worth it to file a state trademark, or is it always best to go the federal way?
Yeah, because so much is done online now, federal is usually the best approach, because the question is, would the product or service you're endorsing potentially be purchased online or viewed online or somehow used online? And if so, then federal is generally the way to go. But I do tell clients, for example, if you have a name of a housing development that's somewhere in Miami, and do they care if someone in Georgia, another state, uses something very similar? If they don't care, then state may be sufficient.
So if it pertains to like a brand, like an online presence, federal is probably the way to go. But if you're opening a restaurant and you're not looking to start a chain, you have one restaurant, maybe the state will suffice. Is that what I'm hearing?
I agree. And there are disputes, even when you have a federal trademark, and there's let's say a restaurant, that was the example you gave, in another state that has a very similar name. Even that can be hard to protect federally, because you've got to have actual customer confusion. And if people are going out to eat in one state and generally don't know about a restaurant in another state, then that's another angle that comes up in federal trademark cases.
What do you mean by customer confusion?
Yeah, customer confusion is generally where a person thinks he or she is purchasing something from one company, but in fact, may be purchasing something from a competitor. And that can happen when names are very similar. And it depends also what the product is. I mean, if it's the name of a university, that's not likely to be confused because people do a hell of a lot of homework and research. But if it's the orange juice on the shelf at the grocery store, then two similar names could be confused for one another.
So like if I'm if I'm an athlete and I go to the University of Alabama, I can't, say, let's change it up and be University of Alabama, right?
That's correct. I mean, we actually have disputes among colleges that use similar names. In fact, one I was involved with in Florida, and but generally speaking, there are a lot of trademark disputes even among medical practices, because they like to use, the name of the city and the type of medicine, and there's not much to it. So you could have two or three very similar, let's say, cardiovascular groups in the same city.
Okay, makes total sense. So now that I think, understand what a trademark is, and I went to law school, and I did not learn this. So that's why it's important to educate ourselves with people like you. Now that I understand what a trademark is, Can you walk us through what the process is to obtain a trademark?
Yes, absolutely. And we do these all the time. We typically have someone coming to us who has launched either a new product line or a new business altogether, or it could be personal. I've had athletes come in and want to do register trademarks for them. And the process is generally working with the government. There aren't a lot of third parties involved unless there's some kind of an objection. So it's me representing a client applying for a trademark and seeing it through to registration, usually on the federal level.
Okay. Now, before filing, is there any processes that one should put in place to decide whether or not they should even look to get a trademark?
Yeah, and that's a great question. Most people just do Google searches first, and that's kind of the common approach. Is you want to see if you're going to name yourself or your company a certain thing, you want to see what else is out there. But what's important about trademarks is that you don't need an exact hit to potentially have a trademark issue, because the test is whether they're confusingly similar, not whether they're exact. So we recommend that we hire, that our firm would hire out a professional search company, and we use one in particular, to run trademark searches in advance to try to determine whether there might be an issue with applying for the mark that someone likes.
So what I'm hearing is before filing for a trademark, it's very important to do the research beforehand so you don't waste your time, money, and energy blindly filing for something that's already taken.
Absolutely, because think about what it takes. You're going to hire, maybe you may have a graphic designer who puts together a logo. You may have ad campaigns. Before you go through all that and the signage, if it's, some physical location, you really want to do your homework. But trademark searches can cost, $1,000. So it's not cheap. So it depends on whether the kind of the circumstances, what's going to be your new product or service, what's the name going to be. There's a little bit of strategy that goes into the decision on running one of those searches.
And we're going to get into name, image, and likeness specifics here in a minute, because I really want to talk about this amazing article that you wrote. But the last thing I want to kind of focus on, on the generalities before we kind of get name, image, and likeness specific is, what are the penalties one could face for violating a trademark? Like if I'm an athlete and I, create a logo and I don't file for a trademark, I don't do the research and I use it. And then it turns out that someone has a trademark for that name or logo and I have violated that trademark. What are the penalties?
Well, that's a good question. What usually happens is the prior user of the mark will send what's called a cease and desist letter. It's a letter that says, we own this particular trademark, whatever it may be, and your use of whatever you're using is too close to what we have, and we're going to ask you to stop. Now, if the parties can't get it resolved, then you can be sued for trademark infringement, and you can be responsible for paying, damages or lost profits, whatever dollars you've made off of the use of a mark that someone else claims the right to use. Maybe you owe them that money.
So
Sure.
If you have a logo and you don't do the research and you infringe on someone else's trademark, you can be sued for the use of that trademark and basically have to pay back every dollar you made, and then be out all of the money you sunk into creating the logo, the branding. So by not filing for a trademark, you're really running the risk of big financial ramifications that could really impact you negatively from a business standpoint.
That is definitely true. It can be very disheartening to someone who's launched a whole campaign and realized when they get a cease and desist letter that someone's demanding that they stop. But yes, you want to register a trademark both to make sure that you're not copying someone else, and also to make sure that nobody else can copy you going forward.
So last couple of questions, because I thought of some more. How long does it typically take from the time you apply for a trademark to actually obtain the trademark?
Okay, that's also a great question. Usually it's about 9 to 12 months if there is no objection by the government. And when you're applying for a federal trademark, generally two things can happen. You could get two bad things could happen. One is you could get a preliminary refusal from the United States government for whatever reason, often because it's too similar to something that's already registered, or you could get an objection by a third party, someone who believes that your application should not proceed.
In the meantime, because student athletes are in school for 4 or 5 years, maybe less, 3 years, 9 to 12 months for some of these athletes is a third of the time they're in college. Is there something they can do in the meantime to get ahead? Or maybe there's a situation where you're waiting for approval, but you kind of have a good idea you're going to get approved where you can move forward. What are some steps athletes can take during that approval process where they can actually get to work using their logos or trademarks?
Right. Yeah. I mean, if, the first thing, and we talked about running a search, which gives you some confidence. Another thing is you can file as an intent to use trademark, meaning you can file even before you've used it. And your filing date is going to act as if you've used it as of that date. It's kind of a little freebie that the government allows you to apply now. And then even if you use it in the future, they're going to treat your filing date as the date of first use. So yes, you can do that. But the delays really in terms of the process are just the fact that once you apply, the government assigns an examining attorney. That takes a couple of months. And then you get your first response back from the government. So it kind of goes back and forth a few times. But like I said, generally, if you don't run into snags, 9 to 12 months on average.
So that intent to file is like a trademark credit card is kind of what I'm hearing.
Yeah, because the general rule is that the prior user usually wins a trademark case. Okay, the prior user, not the first to file, but the first to use a mark usually wins in a dispute. But this is kind of an exception to the rule where the government is encouraging people to file. And they say, look, even if you're second to use this thing, if you filed first, you have priority over the other guy.
Awesome. So now I feel like I finally understand what a trademark is, why it's important, and the process to obtain it, and what I can do with it once I have it. Like I finally get it. I'm 34 years old, went to law school, and I finally today, interviewing you for this podcast, finally get it.
Well, thank you.
So before we kind of get into the nitty gritty on name, image, and likeness, what are your thoughts on name, image, and likeness?
I'll tell you, at the very beginning, I wasn't sure, but I heard a comment on live television by, I think it was Jay Billis, the college basketball.
You're sure you're okay mentioning Jay Billis? You're a Carolina Tar Heel.
I am okay. I really am a huge fan of Jay Billis because I think he's brilliant, and he was even an attorney at a law firm up in North Carolina too. But he said something to the effect that college athletes are like the only people in the United States who are not allowed to profit from their name, image, and likeness. And when I thought about that, I thought, that says it all. I mean, it should be opened up. I think that they made the right decision. And I think the key is to, through time, develop the best practices and policies so that colleges can't, cheat, basically.
You're preaching to the choir. I get interviewed all the time, and I speak on this all the time. And are you pro player? Are you pro NCAA when it comes to name, image, and likeness? Where do you stand? And my thing is, this has been a long time coming. Student athletes have been fighting for this right for 115 years. It's great, but we need uniform laws. So everyone's playing by the same rules. And we need the proper rules to ensure that no one is taken advantage of, no one's gaming the system, and that name, image, and likeness is here to stay. And it's a positive thing rather than a negative, because if we don't have certain policies and procedures in place, the system will get taken advantage of, and all the great things that we're hearing about will go out the window. And I think we're on the same page with that.
Yeah, I totally agree with that.
So you wrote this article. I'm going to read the title here. What's hidden in the new NCAA athlete endorsement rules? And it's about intellectual property considerations. And I had never met you, David, and I stumbled across this article and I was completely blown away. So from a social media aspect, you write, well, first, let me ask you, what prompted you to write the article?
Well, what really prompted it was July 1st happened, and all of a sudden the rules changed as of July 1st of 2021. My law firm put together a focus group. We got on a conference call. We had different attorneys with different practice areas, mine being trademark law. And then I started to think, you know what? I should write an article because it's timely, number one. And people getting into NIL discussions should know something about trademark law.
Love it. So you wrote in your article that one area that has received less attention is the intellectual property concerns of businesses and athletes. And you kind of talk about small and mid-sized businesses and how they might be the biggest buyers for college athlete endorsements, but these businesses might not have much exposure in the complexities of IP law. Can you kind of explain the importance of that and what businesses and student athletes alike need to be careful of when it comes to trademark infringement?
Yes, there can be issues between, you know, if you look at the three players, you've got the university, you've got the business, and you've got a student athlete. Hopefully everyone's on the same page and it all goes perfectly, but there can be issues with either outsiders. You know, there could be outsiders in another state who feel like what the person's doing in your state is an infringement of what they've done. Or there could be issues that arise among university, college athlete, and the business, like what happens if the student athlete wants out. You know, I could go through a bunch of different, different examples of things that should be ironed out from the beginning.
See, when I read the article, that paragraph is actually what hooked me the most, because we've been talking about that forever at Athliance, right? Everyone's focused on the national brands, right? Like the Gatorades and the Coca-Colas. That's probably 1% of NIL, if that, right? But those companies aren't going to put a student athlete or themselves at risk because they have robust legal teams, right? They know what they are doing. They've been in this game for a long time. To me, the risk always was with the small businesses, the mom and pop shops that want to get involved and work with athletes in local college towns or the hometown of college athletes, because those companies and businesses don't have that robust legal team and don't know what they can and can't do necessarily. And so that's where the risk lies. And so I think that's something that not enough people are talking about. And I was really drawn to your article because you shine light on that. And so I'm really glad that we had an opportunity to kind of discuss that on that previous question. And I think you nailed it, the nail right on the head. So I appreciate that.
Thanks.
Now, in your article, you wrote, social media platforms are primed for commercial content. What does that actually mean for student athletes? And can you give an example?
Well, as the example, one of the examples I put in my article, Olivia Dunn, the LSU gymnast. I actually went to her page just last night again to double check, but sure enough, she has over 5 million followers. I mean, that's outrageous.
And had you ever heard of Olivia Dunn before name, image, and likeness?
I did not know who it was.
It's why when we talk with others about name, image, and likeness, performance is one indicator of marketability, but it's not the sole indicator. And name, image, and likeness is driven by marketability. And I think there's no better example than Olivia Dunn. So talk to us again about why it's important from a social media content to maybe have a trademark.
Well, for social media, because so many things are being viewed and shared and posted constantly, if you're going to undertake an NIL project with a business and your university, you need to protect yourself so that you don't have other people kind of sabotaging the deal, so to speak. I mean, there will be certain obligations of the student athlete. There will be certain payments made, and you can't have just anyone. You can't have your stuff reposted like on a website that maybe is something that you don't approve of. You have to protect yourself.
And we mentioned earlier the differences between federal trademarks and state trademarks. It's true that if posting on the internet or social media, that's governed by federal law and has federal reach, national reach. So for trademark logos, if you want to post on social media and the internet, you should probably obtain a federal trademark, correct?
Totally agree. And, you had mentioned too, the universities, of course, they have their own marks that are extremely valuable. And there will have to be some kind of an understanding between the student athlete and the university. For example, if you've got your own trademark as a student athlete, can you use it in connection with the university logo? Or, what kinds of statements? Can you name the name of your stadium in a text? That kind of thing, you need to kind of iron those things out from the beginning.
When I'm on social media and I'm seeing college athletes build their brands, because I think we're seeing that, and I'm seeing a lot of college athletes with logos. In their logos, most or a lot of these athletes use their name, right? Like, for example, my name is Peter. Peter's Place. If I wanted to kind of create a business where you came to my restaurant, it was called Peter's Place. You wrote surnames, which is someone's name, might not win trademark protection. Can you kind of talk about that and what you mean by surname and why you might not gain a trademark for that or be protected?
Sure, absolutely. I mean, and your example is a good one. Peter's Place. Let's say that that's what you want to use. How many Peters are there in the world, really in the United States, when you're talking about federal trademark law? Because that's their trademarks are territorial. So because there are millions of Peters in the United States, what gives one person the right to get a federal trademark and thereby try to prevent other people from using it? It's for common names. It can be difficult. There's a United States government objection actually to an application that a mark is primarily merely a surname. And of course, a trademark lawyer can come up with strategies to avoid that kind of objection, from the beginning.
So in your article, you use the example of the Tebow burger. Why, if I wanted to trademark, if I were Tim Tebow, the Tebow burger, might I run into some issues?
Well, you could run into issues. First of all, you have to see what else is already, registered as a trademark that involves the name Tebow, because there could be some other things out there. And as you might have read, which I found extremely fascinating, the Notre Dame versus Oklahoma dispute with regard to the sign, the famous Notre Dame sign about play like a champion today. But you could run into issues with prior users, and you also may run into an objection that it's just a surname, in which case you may add a logo, you may add color and detail and artwork and maybe a slogan. And the more distinctive you can make your mark, generally speaking, the easier it is to protect.
So let's break that down, because that's actually my next question. You write, trademarks must be unique. Can you kind of expand on that and define what you mean by unique?
Well, by unique, I mean one of a kind. It's got to be something that draws a mental line between the product and the business that sells that product or service. So you want to stand out, be distinctive, be different from other marks out there. And, you don't have to use something that is already a word. I mean, look at Google. If you come up with a name that is made up completely, it has no meaning whatsoever in the English language, those are the absolute strongest marks because all they do is identify you.
That's awesome. Now, this kind of transitions us into something we spoke earlier, but I kind of want to touch back on. It sounds like a lot of these potential issues and disputes could be avoided with a search, making sure and doing the research to find out whether or not your logo or your trademark name is already taken or used. Can you talk to us, though, about what you mean by get professional help when it comes to a search rather than just Googling?
Yeah, a professional search is something that, law firms don't do these themselves. They hire companies that are professional research companies. But for example, if you've got a trademark and it's a word, there could be something similar out there by putting a little I before it, or by putting a .com after it, or by changing the E to an O or something, changing the spelling or making it plural. These professional search companies run all kinds of different variations of what your proposed mark is within that industry. Remember, they're industry specific. And then they put out a binder. So you will get a 300-page, at least a 300-page, either a physical binder or a PDF that lists all the potential conflicts that they found. And it's not just online. It's like trade journals and business names in other states and that sort of thing.
Great. So we've talked about the search and how important that is. And as you've kind of gathered, everything that we do and talk about is protection, protection, protection. And oftentimes people don't want to hire lawyers until it's too late. And I get it. As a lawyer, I get it. It could be pricey. There could be issues there. Why and when should a student athlete hire a trademark attorney if they want to obtain a trademark for their name or logo?
Yeah, great question. I mean, first of all, I think that a student athlete doesn't need to be bogged down with legal things when they're first looking into NIL opportunities. Go out and enjoy the opportunity. But when pen is going to hit paper, the university doesn't represent the student athlete. The university may review it and vet the deal somewhat, but it's going to be a business and a student athlete whose the terms of their deal govern when something happens. Like particularly if you no longer want to endorse this product, can you then just take your trademark to a different company and start using it with them? All those kinds of things need to get ironed out before you sign.
I think it's a great point because these student athletes are still student athletes on the field and in the classroom. But now, from a name, image, and likeness and brand positioning status, they are professionals, right? You're engaging in business. And so you need to treat this, if you're a student athlete engaging in NIL, as a professional. And as we know, professionals make sure that they hire legal help to make sure that they don't do anything wrong, because those decisions have real ramifications, which could cost you some real money. And name, image, and likeness can be amazing if you treat it the right way. And I think that's what I'm hearing from you.
Yeah, I totally agree. I mean, if done well, I think everyone benefits. I think it's good for the student athlete and the university and the business that is paying for the name, image, likeness. But you just need to be careful about how it's done. And if a student athlete doesn't want to seek out an attorney, maybe you ask up front, hey, I would like to hire a lawyer to look at this. Would you reimburse me for my legal fees in doing so?
Can't hurt to ask. I've seen it done multiple times, and I've seen it be agreed to. So I think that's a really creative way student athletes can try to lessen the financial burden of building a business while engaging in NIL activities. I absolutely love it. We've talked about a lot of things, right? Searches, lawyers. What are some other type of trademark services out there that student athletes should be aware of?
Well, number one, be really aware of scams that are out there. I mean, it's almost it's kind of a problem within the trademark industry. There are all kinds of emails that you may receive about, protect yourself with, our trademark, program, and really all they're doing is putting your mark in like a book that they publish. I mean, it does nothing. It confers no rights. So number one, watch out for scams. And number two, trademark services really just fall into two categories. You've got the protection of your own mark, and then that's really between you and the federal government. And then number two are resolving disputes among trademark owners, which is between you and a third party.
And I think something we haven't talked about is if you have a trademark and you have a logo that is trademarked and someone goes to use it, you can sue them and you can make sure that you're the only one that uses that logo, which makes you more valuable from a brand standpoint.
Yeah, there's two ways to go about that. One is when someone's using something, and remember, it's whether it's confusingly similar. It doesn't have to be exact. So if they say, oh no, mine is plural and yours is singular, that is not necessarily good enough for them to avoid liability. So you either take one approach and say, we're going to serve a cease and desist letter and require you to stop altogether, or you license your mark to them in certain situations and make them pay you money to use it.
Yeah, like a good example of similar is like, all right, I want to use the word Alabama. I can't, so I'm going to change it to Alabama, right? That's still an infringement. That's still a violation of the trademark.
Yeah, and it all depends on the overall look and commercial impression. So yes, changing one letter it rarely makes it different enough. There are cases about transposing words. Maybe yours is there was a famous case between two big restaurant chains, actually, which had names where the first word of one was the second word in the other. And it's all about general commercial impression. I mean, it could be that the colors of the logo are different, or the slogan's different, or something, the shape of there could be the shape of the star design that's different. But if you'll know, I mean, if you look at something and it looks kind of like what you're doing, you'll pretty much get the feeling that someone is trying to trade off of everything you've built.
Yeah, I think that's important to note because even I think colors can come into this. I believe there was a case out of Texas where the burnt orange and white was actually being used by a company, and Texas was able to sue. And I think there was some issues with some trademark infringement on that, which is very interesting. It's not just words and just logos. It could even go down to colors. So I think that's also very unique that no one's thinking about. So much goes into this, right? To protecting yourself. So much goes. Yeah.
Yeah. And Pete, not even just colors. I mean, those are kind of rare, but I think FedEx might even have, or UPS might have a trademark registration for the color brown in connection with mail delivery. But, it also could be like the little jingle on NBC Sports, the little, there could be yeah, that could be a trademark. It's really, now, when I said before, it's usually the name of a business or a name of a product or a slogan or a design, but it could even extend to things like that.
So we've spoken a lot about what a trademark is, how to get a trademark, how to protect yourself, whether someone's using your trademark or someone thinks you're using their trademark. Right. We've talked about name, image, and likeness and how this fits into this scope. I think we've covered a lot. What is one or two things that you want student athletes to remember after they listen to this podcast? What are some takeaways?
Well, first of all, congratulations. If you're a student athlete right now and you're living your best years right now, going through this whole exciting time of college sports. So enjoy, number one. Don't get too bogged down in the legalities right now. Enjoy it. Look at what the opportunities are. Be creative. If someone approaches you, maybe you have a dialogue. If you want to, there's also group licensing opportunities too, which may not just be, you with a business. It could be a whole group licensing situation. But I would say, other than just enjoy these days, before you put pen to paper, you really should talk to someone to make sure your best interests are being protected.
I love it. Dave, you've been so helpful. You've really enlightened myself, and I'm sure our listeners, on intellectual property considerations as it pertains to name, image, and likeness. Tell our listeners where they can find you and how they can reach you.
Sure. I am my name is Dave Hathaway. I am at Dean Mead Law Firm. We're a Florida-based law firm with approximately 5 or 6 offices throughout the state, but I'm in the Orlando office, and our website is deanmead.com. And, we use first initial last name for emails, and that's how you can reach me, and also other contact information's on the website.
Dave, you've been great. This is one of my favorite episodes of SME You. I think we talked about some issues and topics that are really pertinent to college athletics today, and a topic that people aren't really discussing, which is trademark and IP considerations. Thank you so much. It's been a pleasure, and keep doing the great work that you're doing.
Thank you so much for asking me. This is something I wouldn't have known to reach out to you. So thanks for letting me have this opportunity. And I'm excited for what the future brings.
Awesome. Thank you, buddy.
Okay. Have a good one.
Take care.